Good afternoon, ma'am. This is Siddhant.
Good afternoon. Good afternoon.
Hi, ma'am. So let's wait few minutes for others to join in so that we can continue thereafter. I hope you're able to share your screen.
Yeah, I can do that. Just give me a moment.
You sure?
My PPT shared. So should I run it or you will run it?
You can run it and share the screen.
Okay.
Just see if it's working once.
Is it?
Just a second. Yeah, it's visible. Yeah, perfect. So we can wait 5 to 10 minutes before we proceed. Sure. Thank you.
हेलो हेलो हेलो
हाँ
थोड़ा चेक में लिखने में भूल हो गया था तो उसको भेजे हैं उसके पास दोबारा नया चेक बनाते हैं। ठीक है। तो इसीलिए उसका नंबर चाहते थे कि वो कहीं मतलब जमा हुआ नहीं करते। तो तुम बोल दो वो चला गया आदमी मेरा। तो सरबाजी से
Hi, Ketki.
Hello, good afternoon, sir.
Afternoon. How are you? Siddhant?
हाँ भैया, good afternoon, sir.
Tumena?
Yes, yes.
Okay. So, thank you very much, Ketki, for joining. So, more people will join now because I have shared the link yesterday. So many people have forgotten that today is the seminar. So again, I have shared.
Sir, I
So,
can't hear
yeah,
you.
my voice is not clear.
No.
Siddhant?
भैया आपका वॉइस नहीं, इट्स नॉट क्लियर भैया, इट्स बहुत दूर से आ रहा है आपका आवाज.
Okay. Hello. अभी अभी better हुआ है थोड़ा. Hello.
नहीं,
Hello.
क्लियर नहीं है.
एक मिनट. हेलो, अभी है? क्लियर है? हेलो.
क्लियर तो क्लैरिटी इज बैड.
जस्ट हेलो.
हाँ,
ठीक है अभी.
परफेक्ट.
Okay. So, Siddhant, we can start session.
यस भैया. ये जो ACI सॉन्ग है, कैन यू शेयर दैट और शुड
तुम
आई?
छोड़ दे उसको, वो दिक्कत होगा वो शेयर करने में. तुम उसको छोड़ के आगे बढ़ जा.
ठीक है. A very, very good afternoon to one and all present here. So let's start the session for today. And by the way, by the time we start, I hope बाकी सब भी जो join कर रहे हैं वो भी सब join कर लेंगे. So the today's session is on Indian Trust Act, and as we know, trust एक ऐसा topic है जिसमें बहुत confusions और gray area सबके mind में रहता है. तो वी होप टुडे दैट आज हमारे बीच में मैम ज्वाइन की है, मिस केटकी मित्तल. आई होप आई एम प्रोनाउंसिंग योर नेम करेक्ट, मैम.
Yeah.
Yes. So Miss Ketki Mittal, she has joined us today to enlighten us and to clear many of our this gray areas and hoping to have a much better knowledge. So this is the first seminar for the allied laws that we have had in this year, and we hope to have again and again. And though then after 2 days also we are having a proper full day session on allied laws in succession planning. So if अगर आप में से कोई को भी join करना है तो do let us know. We will share you the link to join. And not to waste our time and move forward, I would like to welcome and introduce the speaker for the day. Ms. Ketki Mittal is a practicing fellow CA and has done her LLB. She has guided experience in wide range of areas covering merger and acquisition, succession planning, international taxation, and corporate laws. She has been actively in core direct tax advisory as well as involved in conceptualizing and implementing a number of mergers and restructuring transactions. She has contributed an article on succession planning, securing legacy and minimizing tax liability in the book of A Definitive Guide to Succession Through Private Trust, a legal, tax, and regulatory aspects, published by Chamber of Tax Consultants. She is presently the Vice Chairman in Direct Taxes Committee of Chamber of Tax and Consultants. She is working as a director in the firm Bansi S. Mehta and Company. A very, very warm welcome, ma'am, to our platform. Thank you so much for your time. I would like to share a small memento. I hope the same is visible. It's a small virtual memento
Thank you.
from ACA towards you. Thank you so much, ma'am, for your time. And now I give the platform to you to please continue and please take us forward, ma'am.
Thank you so much.
Okay.
Thank you for such a warm
So,
welcome.
before Ketki, you start. So let me give a brief background to all our audience that why we have organized this seminar in such a short period of time. But before that, I will request Ketki has joined all the way from Mumbai, and if her camera is on, if assume she switches off her camera, then will you be interested in this seminar? So, in the same way, on behalf of Ketki, I request each one of you, please switch on your camera so that at least we can see your facial expression. And the topic is also very complicated, not very simple, not very easy to handle. So, she will also see your facial expression. Based on that, वो अपने लेक्चर को टफ और इजी बनाएंगे. So again, my humble submission, if it is possible, and switch on your camera. So, friends, the background is Ketki is from Bansias Mehta from the team of Yogesh Thar sir, and from last 6 months, ACA is working very hard to organize this session on succession inheritance, and we requested none other than authority on these subjects, Mr. Gautam Doshi and Yogesh Thar sir, and since then we were in touch with Ketki, and we had long deliberation on that Friday session, what all topics will be taken care by Mr. Yogesh Thar and then with the team of Gautam Doshi sir. So जब हम लोग इनसे बात कर रहे थे तो बात करते करते वी realized कि why not to have a brief session on the basic concepts of trust, so that when on 8th on this 13th of March, Yogesh sir and Gautam sir will talk, so we all audience have a background, what he is talking and from where he is coming. So then we requested Ketki. In fact, we requested Ketki for her physical presence in Kolkata, but somehow she was occupied with other seminars and her commitments, so she could not. So then she accepted our request for this virtual session, and definitely she has promised that at a suitable point of time she will definitely come to Kolkata. So, friends, this entire session is a kind of clarity of basic concepts before the session of Friday, and already told by Siddhant that those who have not registered for Friday session, please feel free to register. And yesterday also we had a detailed talk with Mr. Gautam Doshi. So this session is going to be very useful for all of us, because we all know nowadays the way things are moving, the kind of uncertainty we all have at whatever income level you are, but everyone is facing some kind of uncertainty. So, as a professional, it is our duty to advise our client on this two succession inheritance topic. So, what all the structures are there, how the things work out. So, in this, I think these two sessions will be very helpful. So, with this, I welcome Ketki on behalf of AC, and thank you very much for your time. So, now I request you to please, you can take your session, and you have sharing right, so you can share your screen from your end only.
Thank you so much. Thank you,
And
Neeraj ji.
let me welcome our past president, CA Susil Pransukha ji. Sir, thank you very much for joining. So I'm not saying any other past president. So, sir, thank you very much.
Thank you, sir. Thank you, Neeraj, sir. Thank you, ACAE. Sir was deliberately right. We are coordinating six months for this program, and sir had an idea that I take it over. And from the bottom of my heart, I humbly thank you for making me a part of it. I am very elated to share my views. Also, I'm very sorry I could not make it physically. Though I would love to once come over this Calcutta and experience the physical audience, but this time because of my paucity of time, it was not possible. But I, at the outset, thank you, Neeraj sir, and thank you, ACE team, for having me also as a part of this. It is immense pleasure, and it is a proud moment for delivering a lecture on this platform. I have been seeing you and the team work with Yogesh sir since 6 years. So once thought that would I be able to ever be on this platform, and today here it is. So I'm very glad for this. So today's session, my friends, is around the background of Indian Trust Act, succession, modes of succession, etc. So I would first like to say that the tax implications, the legal implications, etc., will be provided on Friday's session. I will just be giving a brief background on how the trust mechanism is, what is a trust, what are the relevant parties to the trust, how does it work, what is the registration requirement, what is the rule of perpetuity, relevant sections in a trust act. I would first like to run you through those things, and then we can have some practical insights of forming a trust. That would be the broad coverage today. Yeah. Is my screen? No, it's not visible. Yeah. So is my screen
Yeah,
visible?
now it's visible. Now it's visible.
Yeah. So before we get into the trust aspect, I would like to run through one thing. Um, as everybody knows, and there's a very famous Latin phrase which says that mors certa est, vita non est. It says that death is certain, life is not. And Benjamin Franklin, in his words, had once said that everything in life is permanent, everything in life is temporary except debt and taxes, which is permanent. So, what happens when a person dies? When our loved one dies, patriarch of the family dies, there are various uncertainties, emotional grieving. It is at that point in time we realize that how do we pass on the wealth to our loved ones, to our next generation. And when you're passing on the wealth from one generation to another or to our loved ones, we want to avoid the tax leakages. We want to minimize, we want to reduce the tax leakages and pass on the wealth from one person to another. It is at that point in time, at the ninth hour, when the panic strikes and we begin to think what has to be done next, whether we make a will, whether we make a trust, etc., etc. So that act of planning how the wealth will pass from one generation to another to our loved ones, and that too in the legal, tax, and regulatory framework, and at the same time to minimize the tax leakages, that entire act is known as succession planning. Now, the term succession is not defined anywhere specifically except in a Bengal Tenancy Act, and it is saying that succession is both tested and intestate. Now, what is tested? What is intested? In case of a tested succession, you have a will. अगर हमने एक will बनाई आज, if you make a will today, and we write down what and how the assets, our property will pass from one generation to another generation or from one family member to another family member, that act is called a tested succession. Whereas if some person dies and he has nothing in written, no instrument recording how he wants to pass, कितना पास करना है, किसको पास करना है, कब पास करना है, that is called as intestate succession. In that case, our Hindu Act provisions, Hindu Succession Act provision, Indian Succession Act provisions will apply. Now, what happens in a succession? एक succession करने के लिए what do you need? Essentially, you need to transfer the property, you need to transfer the rights, obligations of the deceased. And yes, what are the relevant factors to do this? It is dependent on the laws applicable at the time of death, type of succession, tested, intested, nature of the property, कि कहाँ property situated है, property क्या है, immovable है, movable है, etc. And मेरा obligation क्या है, the person who's dying, उसका उस property के लिए obligation क्या है. These are some of the factors which are very, very relevant when we do a succession planning. Essentially, at that moment when you're grieving, when there is a lot of tension, we cannot think about things. So it is generally advised, it is generally preferred that today, when I am in a calmer state of mind, I plan out, I lay a roadmap and do my succession planning and lay out the modes of how to do the succession planning. There are some certain modes defined of succession planning, which I would like to just spread out here. The first one is modes of succession planning, nomination and a will. As we all know, a will is prepared with the person's intention that on his death, how the property has to pass, to whom the property has to pass, how much quantity of what has to go to him, who will execute his will. There has to be a person who has to get his will executed also. So, how the property will go to whom, when, etc., is done under a will. We have to note one thing: the person who prepares the will is called a testator. In case of a will, the property generally passes or property passes on the death of the person preparing the will. A will cannot be made today and property passes today, will is essentially made, and on the death of the person writing the will, the property is passed under the will. This is a very common, simple, easy way of passing the property. The second is a nomination. Under the Companies Act for shares, under the bylaws, under the Cooperative Societies Act, we fill the nomination form that after me, this person is the nominee, and the property will pass on the death on nominate to the nominee concerned. Then the most important is a trust. I make a trust, I declare a trust today. The person declaring the trust is there, for whom the trust is declared, what the property will pass, etc., is written in the trust. The other thing is a testamentary trust. Now, what is a testamentary trust? That will come to little later, but for now we can take it. It's a trust which is created under a will. I write my will, I create a trust under the will. The trust operates on death. That is a testamentary trust. Then we come to the other thing, which is a structured instrument, like partition of HUF, partnership firms, shares with differential voting rights. Here, I would like to pause for a minute, and I would like to ask the audience that amongst us today, how many of us have ready and prepared with our will? Or how many of us have thought, okay, today we'll make the will, let's make the assets? Anybody who has made it, anybody would like to share the experience? Or anybody who's contemplated to make it and is thinking it's a lengthy process? सुशील जी, आपने बनाई है will?
बनाई है.
Okay. Okay. So, with this, I would like to go on to, अगर एक मैंने will बनाई आज, if I make a will today, and if the will is to be executed, potential, possible, what all risks can be there in a will? Inherent risks. One is that if there are, suppose जैसे सुशील जी ने बनाई और समझो उनके दो बेटे हैं, so there is a possibility that the two sons can produce two wills, multiple wills produce हो सकती है कोर्ट में, एंड कोर्ट को 20-30 साल लग जाएंगे एक एक्चुअल विल डिसाइड करने में. सो दैट इज अ डिफेक्ट अ विल सफर्स फ्रॉम. सेकेंडली, अ विल is never executed at the lifetime of the testator. Will जब तक जिसने बनाई है, जब वो जिंदा है, कभी भी cannot be executed. A will is always executed after the death of the testator. तो आज अगर मुझे देखना है कि मेरे एसेट्स मेरे बच्चों को, मेरे वाइफ को या मेरे किसी भी फैमिली मेंबर को कैसे पास ऑन हो रहे हैं, तो वो आज पॉसिबल नहीं है. सेकेंडली, एक एस्टेट ड्यूटी का एक टैक्स लॉ है जो पहले था अब नहीं है. सो द पॉसिबिलिटी कि वो एस्टेट ड्यूटी वापस आ जाए, एंड अगर डेथ पे प्रॉपर्टी पास हो रही है विल पे, तो वो टैक्स अभी वापस ले भी हो सकता है. दैट इज अ पॉसिबिलिटी. तो ये सारे एक डिफेक्ट्स है एक विल के अंदर. जस्ट 2 minutes आई वुड जस्ट लाइक टू गो टू एस्टेट ड्यूटी क्या है, क्या था और क्यों ये डर है अभी भी. So estate duty was there previously on the statute book, and under that वो old एक law था 1953 का, where it was saying that whatever value of property, be it immovable, movable, which passes on the death of a person, at that point in time, there is a percentage of tax you need to pay as estate duty to the government. तो ये essentially एक tax था which was levied when a person dies. बट इसको 1985 में अबॉलिश कर दिया था फॉर टू रीजंस. वन इज कि जो एडमिन कॉस्ट था ऑफ मेंटेनिंग एस्टेट ड्यूटी ऑफिसर्स, कैलकुलेटिंग ड्यूटी वाज मोर देन द रेवेन्यू जनरेटेड. एंड सेकेंड वाज दैट देयर वर टू टैक्सेस. एक वेल्थ टैक्स भी इंसान भरता है जब वो जिंदा था, एंड सेकेंडली एन एस्टेट ड्यूटी ऑल्सो वाज देयर. सो फॉर दीज टू रीजंस ये टैक्स अबॉलिश हो गया था. 1989 में एक वेल्थ इनहेरिटेंस बिल हैड कम इन टू प्ले, जब ये वापस रिसरेक्ट होने वाला था. दैट टाइम द लोकसभा में इंट्रोड्यूस भी हुआ था बिल. फाइनेंस मिनिस्टर वॉज मधु दंडवते. बट देन ये बिल इज नॉट येट पास्ड. बट देर इज अ फियर, देर इज अ प्रोबेबल रूमर और अ प्रोबेबल थॉट दैट एस्टेट ड्यूटी कैन कम इन टू पिक्चर. सो इफ एस्टेट ड्यूटी कभी भी आया फ्यूचर में, एंड एक विल के अंदर इफ आई एम पासिंग माई प्रॉपर्टी इन अ विल, एट दैट पॉइंट इन टाइम जो मेरी प्रॉपर्टी रहेगी, मूवेबल वैल्यू, इमूवेबल, उसकी जो वैल्यू रहेगी उस पर एक एक्स अमाउंट का ड्यूटी वुड बी लेविड एट एक्सटेट ड्यूटी, एंड दैट वुड बी पेएबल टू द गवर्नमेंट. इज अ प्रोबेबल फियर or probable thing which a will suffers from today.
पापा लेके घूम रही है, बोले ये तो मेरा है। पैसा लो, संभाल लो भाई, तू तो बहुत बड़ा बात है। पैसा दो।
So moving on to the next part of it, I would like to start with the provisions of the Indian Trust Act. So, firstly, what is a trust? What is a trust in normal parlance? What does a trust do? Why do we need a trust? या एक ट्रस्ट क्यों हमें फॉर्म करना चाहिए? So for that, we will need to understand what is a private trust. So basically, trust in simple words is a transfer of property from one person to another. Person who transfers the property, person who receives the property for the benefit of the third person. It is an obligation which is attached to the ownership and arising out of the confidence reposed accepted by the owner for the benefit of the third person. This is the definition of trust under the Indian Trust Act. We will decode every part of it. But in layman terms, a private trust is an arrangement जहाँ पे there are 3 to 4 parties where one person passes the property to another person, and that person who receives the property is a trustee. The person for whom it is received, जिसके benefit के लिए receive होता है, उसे हम beneficiary बोलते हैं. ट्रस्ट क्यों फॉर्म किया जाता है? एक लीगल फॉर्म होता है. इट्स मेड इनटू अ लीगलाइज्ड फॉर्मेट हो जाती है. इट गिव्स अ गारंटी टू दैट पर्सन हु सेटलिंग दैट ओके दिस इज द वे उसकी प्रॉपर्टी ऐसे हैंडल होगी, दिस इज द वे हाउ इट विल गो टू हिज नियर वंस डियर वंस. सो एक फॉर्मेट, एक लेआउट, एक बॉक्स पिक्चर क्रिएट कर देता है ट्रस्ट. Now, in the trust, the essential parties in a trust are settlor, trustee, beneficiary, a trust itself. Then we have the trust deed and we have the assets settled. Let us understand one by one ये एक एक पार्टी का रोल क्या है, and then हम ट्रस्ट के बेनिफिट्स इससे समझ सकते हैं. फर्स्टली सेटलर को नॉर्मल पैरेलल्स कैन बी सेड एज कंट्रीब्यूटर, कैन बी ऑल्सो टर्म्ड एज ऑथर. The settler is the person who makes the trust. He is the one who wants to put the property in the trust. So settler vests his property in the trust and conveys the legal title to the trustees. So for example, today see if I want to make a trust for my brother and मेरे पास 2 immovable properties हैं. So I will want to make a trust. Property मुझे transfer करनी है. So I will be called the settler. I will give the legal title of the property to the trust. I will settle the property in the trust and मैं वो property को convey कर दूंगी trust के हाथ में. तो मैं एक settler बोली जाऊंगी. Trust एक form हो जाएगा private trust. Now if I want, I will have my mother or my father as the trustee of the trust. What does the trustee do in a trust? What is the trustee's role in a trust? A trustee holds legal assets, legal title of the trust and manages the property. Trustee is like a custodian, you can say. It's like a watchdog in simple languages. It's like an obligation हमने trustee पे डाला है कि trustee जो है, my mother, she will hold the title to the trust. She will manage the assets of the trust and property of the trust. Suppose if tomorrow the immovable property which I have put in the trust, it is going to get a very big high, so she can decide to sell the property of the trust and get the revenue out of the trust. But trustee will never be a party to the income of the trust unless trustee beneficiary बनता है. तो अगर trustee सिर्फ एक trustee है तो उसका रोल लिमिटेड है, like a custodian, like a legal owner. उसके पास सिर्फ legal title है. अगर उस एसेट से कुछ अप्रिसिएशन होता है, कुछ डिविडेंड आ रहा है, कुछ इनकम आ रही है, तो दैट पार्ट अ ट्रस्टी विल नेवर बी एंटाइटल्ड टू. इट इज ओनली रिस्पॉन्सिबल फॉर एग्जीक्यूटिंग द ट्रस्ट. मतलब वो एक फंक्शन बॉडी है जो ट्रस्ट में काम करने के लिए फैसिलिटेशन करेगा. ट्रस्टी at times settler and trustee can be separate, not necessary it is the same. Now in my case I am the settler, my mother is the trustee. So trustee के लिए बहुत important है कि जो settler है वो objects लिखे कि ये property मैंने settle की है, ये property will go to whom, ये property कब बिक सकती है, ये सारी चीजें एक trustee को जानना बहुत जरूरी है. So when we are making a trust, ये सब चीजें मुझे lay down करना पड़ेगा कि आर्टिकुलेट करना पड़ेगा कि नहीं ये ऐसा होना चाहिए, ये वैसा जाना चाहिए, प्रॉपर्टी इसको ही बेचना, ये प्रॉपर्टी बेचना ही मत। तो ट्रस्टी अकॉर्डिंगली मेरे इंस्ट्रक्शंस पे एक्ट करेगा। द थर्ड इंपॉर्टेंट एंड मोस्ट इंपॉर्टेंट पर्सन इज अ बेनिफिशियरी। इन माई केस माई ब्रदर इज द बेनिफिशियरी। बेनिफिशियरी कौन होता है? बेनिफिशियरी इज अ पर्सन फॉर हुज बेनिफिट अ ट्रस्ट इज क्रिएटेड. So today, if whatever income the trust is getting, say if I put shares, तो जो dividend आया, say if I put a property, the rent which has come in the trust, all that income, all that benefit, and tomorrow when the trust is extinguished or the trust comes to an end, the property etc will go to my brother. He is the beneficiary. In layman's term, सब उसका ही है, वो इकोनॉमिक ओनर है, वो एक्चुअल ओनर है सब कुछ का. Just that today it is held in a trust form, but actually it belongs to him. So whatever income assets is there in the trust today, that belongs to the beneficiary, and he is the owner, actual owner, beneficial owner. So beneficiary is the main party to the trust. देयर इज एन अनसेड रूल इन ट्रस्ट एक्ट दैट आप तीनों नहीं हो सकते हो. जैसे मैं हूं, मैं ट्रस्टी, बेनिफिशियरी और सेटलर तीनों नहीं हो सकती हूँ. मैं 2 आउट ऑफ 3 हो सकती हूँ. मैं 2 आउट ऑफ 3 का रोल कर सकती हूँ. आफ्टर दैट द, और हाँ, बेनिफिशियरी कैन बी एन इंडिविजुअल, इट कैन बी अ कंपनी, इट कैन बी एन LLP, इट कैन बी अ पार्टनरशिप फर्म. Beneficiary can be anybody, it can be a lot of relatives. There is no end to this. The next important thing is a trust property. What is a trust property? The asset which I settle in the trust. Suppose if I have an immovable property, or suppose if I have a share which I want to put in the trust, that property once I have conveyed, या मैंने जब legal title दे दिया है, तो जो ट्रस्ट मैंने फॉर्म किया है उसके अंदर जो प्रॉपर्टी गई उसको हम ट्रस्ट प्रॉपर्टी बोलते हैं. It is advised, it is always better that the property which I'm putting in the trust, the title is clear. एक आइडेंटिफाइबल प्रॉपर्टी हो. फॉर एग्जाम्पल, इफ आई एम पुटिंग अ लैंड, I just put a land, but that land has 5-6 plots. 1-2 plots are identified. 3-4 plots are in litigation. उस पर bifurcation नहीं हुआ है, boundary नहीं बनी है. So if it is not identified and I am not clear, I don't have the clear title, I cannot put it in the trust. तो एक property or whatever property I want to intend to put in the trust, title of the property should be clear. It should be identified. It should be defined. What I can put in the trust? I can put cash. I can put gold, I can put land, I can put building, I can put shares, I can put listed shares, I can put my private company shares in a trust. All these things I can put in a trust, and then that becomes a trust property. One more important thing in a trust is a instrument, a document, या एक लीगल पेपर जो बोल सकते हैं ट्रस्ट का, वो दैट इंस्ट्रूमेंट इज कॉल्ड अ ट्रस्ट डीड. सो अगर हमने एक ट्रस्ट बनाया है तो एक एविडेंस भी होना चाहिए कि व्हाट इज इट. सो अ ट्रस्ट मस्ट बी एविडेंस बाय ट्रस्ट डीड, इंडेंचर ऑफ ट्रस्ट डीड और एनी अदर इंस्ट्रूमेंट. And that trust deed has to set out the objectives and the terms governed in the trust. मतलब सिर्फ if I want to make a trust today and I don't want कि my immovable property has to be sold, it has to be used only for running a factory on it, that objective या that rational या मेरी ये सोच या मेरी ये थिंकिंग या मेरी ये डिमांड, जो भी आप बोलो, ये मुझे ट्रस्ट के डॉक्यूमेंट में लिखना है कि ये चीज के लिए आप यूज कर सकते हो. आई वॉन्ट इट टू बी यूज, मेरी जो प्रॉपर्टी है सेटल की, कि वो दैट हैज टू बी यूज फॉर माई ब्रदर ओनली, दैट कैन नॉट बी यूज फॉर एनी पब्लिक एट लार्ज. आई डोंट वॉन्ट इट टू गो टू चैरिटी, और आई डोंट वॉन्ट इट टू बी सोल्ड एंड यूज एंड गिवन टू एनी बडी रैंडमली. सो दैट ऑब्जेक्टिव, मेरा माइंड में क्या थॉट है, what I want to do with the property, how it has to be used, that I have to document in the trust deed. इट इज अ लीगल डॉक्यूमेंट. इट इज लाइक अ चार्टर. आप कंपनी बनाते हो तो एक चार्टर बनाते हो, आप अपनी पार्टनरशिप फर्म एंटर करते हो तो एक चार्टर बनाते हो, लॉज एंड रेगुलेशंस ले करते हो. सो एक इंस्ट्रूमेंट इज लाइक अ लीगल चार्टर. इट इज लाइक अ डॉक्यूमेंट जो टर्म्स एंड कंडीशंस ऑफ गवर्निंग अ ट्रस्ट, लीगली रन करेगा, ट्रस्ट कैसे ऑपरेट करेगा एक्सेट्रा, ये वो ले डाउन करता है. There is one more important concept which I want to highlight in the parties of a trust is a protector. जनरली प्रोटेक्टर इंडियन ट्रस्ट में इतने नहीं देखने मिलते हैं. फॉरेन ट्रस्ट में ये बहुत कॉमन है कि एक प्रोटेक्टर भी होता है. इंडियन ट्रस्ट में ये फिनोमिना कम होता है, बट देर इज अ पॉसिबिलिटी एंड देर आर केसेस में देर इज अ प्रोटेक्टर. इट इज नॉट मैंडेटरी कि आपको प्रोटेक्टर होना ही चाहिए, यू कैन अपॉइंट वन। ये
Let's say our partner with us. IAGS is the organization or the association.
सॉरी, आई कांट हियर यू। हेलो Siddhant, I can't hear what the query.
Can you please send the query again, maybe on chat?
Okay. Can you read it out, please?
No, the query has not yet come on the chat. I'm
Okay,
saying.
okay. Okay, okay,
Yeah,
okay.
so maybe query जब बाद में आएगा, we will take it up again towards the end.
Okay. Okay, okay. So should I continue?
Yeah, please, please.
Just one request, आप query पढ़ लेना ना अगर आती है तो, because मेरे को वहां दिखेगा नहीं.
Definitely, definitely. कोई आएगा तो I will let you know. Yeah.
Okay. So where were we? We were on the protector concept, right? Yeah. So in Indian context, protector is not mandatory. Protector is one who can be appointed. When do you appoint a protector? Usually, if there is an Indian family, there are large business houses who make a trust. Family member is only appointed as a trustee. But when a family member cannot be a trustee, you appoint a protector. Protector is like a watchdog again. The role of a protector is that he watches over the trustees that their actions are proper, they don't terminate, they are not doing some misconduct. So basically, for all these things, you need a protector, and a protector may be appointed. One more important thing which I want to point out here is a trustee can be a trustee individual also. It can be a company also. Where you want to have, suppose if you have a company which is shares, private company shares you're putting in a trust, and you want to have the control with the father and mother both, then you form a company shares, trustee company, the company's trustee company shares are held by father and mother, both are executing control of the trust. So that is also possible कि आप trustee एक individual भी रख सकते हैं. A trustee can be a private company also. Usually in big business houses, big families, where you want to have the control in with 2-3 people, you can have a trustee company. वो भी एक option है. So the question which comes here is कि हम एक ट्रस्ट क्यों प्रेफर करें, या ट्रस्ट करने से what is the benefit, या what is it that I'm getting. I would like to say here is that trust एक classic mechanism है where legal ownership और beneficial ownership separate हो जाती है. Meaning that today if I am a father, I want to not give the control of the shares to my children, saying that वो लोग बेच देंगे, they will not invest in a right opportunity. I can park that share, I can put that share, वो shares मैं आज एक ट्रस्ट में डाल सकती हूँ. आई विल कंटिन्यू टू बी द लीगल ओनर, क्योंकि मैं ट्रस्टी या मैं या मेरी वाइफ बन सकते हैं. तो अगर कोई डिसीजन लेना है कि शेयर्स बेचने हैं, रखने हैं, या इनकम कैसे करना है, या ये बेच के कहीं और फंडिंग करनी है, या प्रॉपर्टी है तो उसको कैसे यूज करना, वो मेरे पास रहेगा. बट एट द सेम टाइम माई चिल्ड्रन और माई वाइफ, इफ शी इज द बेनिफिशियरी, वो उसके फ्रूट्स खा सकते हैं. मतलब उसका जो इनकम होगा, बीट डिविडेंड, बीट रेंट, दैट ऑल कैन बी enjoyed by my family members, by the beneficiaries. It's a classic mechanism where children can enjoy the assets, control remains with the parent. Okay. And also, if I have a family owned company, family owned business, then this mechanism serves the best. Also, estate duty का रिस्क नहीं होता, बिकॉज एस्टेट ड्यूटी डेथ पे होती है. इन दिस केस प्रॉपर्टी पहले ही पास हो चुकी है, तो एस्टेट ड्यूटी नहीं होगी. सेकेंडली, आपका जो अनसर्टेनिटी है कि मल्टीपल ट्रस्ट होंगे या चैलेंज होगा, वो एक चैलेंज नहीं होता है. ऑल्सो एज अ सेटलर यू कैन सी योर प्रॉपर्टी पास इन द लाइफ टाइम. सो ये इनहेरेंट एडवांटेजेस है ऑफ अ ट्रस्ट, ऑफ सेटिंग अप अ ट्रस्ट. सो ये बेसिकली एक प्राइवेट ट्रस्ट का मैकेनिज्म है. एज वी ऑल नो that there is a possibility that you can set up a public trust also. Public trust is for charities where have to, beneficiaries will be public at large. कुछ social obligation है, कुछ religious obligation है, etc. etc. In that case, तो taxation laws और सब कुछ अलग ही govern करता है. But just these are the two basic types of trust, private and public. Now, having said that, ये parties हमने explain कर ली है. I would like
Uh,
to run.
there was one query which has come up. So should we take the queries at the end or can we take it?
जैसे आप बोले. However you want to start.
क्यूरी
हेलो.
लास्ट में मैडम क्यूरी लास्ट में ही लीजिए.
सो
अच्छा,
दैट फ्लोर नहीं ब्रेक होगा. आप कंटिन्यू करो फिर.
ठीक है, आप खाली क्वेरीज नोट डाउन कीजिएगा
या श्योर.
क्योंकि वो शेयर टैब में दिखती नहीं है मुझे, तो उसके लिए.
नहीं डेफिनेटली हाँ.
Okay. With this, I would like to move on to some of the important clauses of an Indian Trust Act. So basically, अगर हमें एक ट्रस्ट बनाना है, if I have to form a trust, I have to form a trust deed. I have to make a draft a trust deed or an instrument of trust. Very common. हर एक कंपनी बनानी है, आजकल तो शादी के भी कॉन्ट्रैक्ट बनते हैं, तो हर चीज डॉक्यूमेंट हो जाती है. तो एक ट्रस्ट बनाना, तो एक डॉक्यूमेंट इज ए मस्ट. दैट इज एन इंस्ट्रूमेंट ऑफ ट्रस्ट, ट्रस्ट डीड बोल सकते हैं, एक्सेट्रा एक्सेट्रा. इंडियन वो डॉक्यूमेंट में क्या क्या होना चाहिए, क्या नहीं होना चाहिए, वो भी आई विल एक्सप्लेन. बट पहले अगर एक प्राइवेट ट्रस्ट है तो उसको इंडियन ट्रस्ट एक्ट 1882 गवर्न करता है. Some important clauses which needs to be kept in mind when I'm planning or I'm doing a succession planning for a trust. ऐसे तो there are many clauses, but I have referred to some of the essential ones here. So first is Section 6 of the Indian Trust Act. ये जो section है, this says what is the essentials of creating a trust. In other words, अगर एक ऑथर है, मैं ऑथर हूं, जैसे मैंने मेरे भाई का ट्रस्ट बनाया आज, तो जब when I'm creating the trust, what are the essential elements I will need in a trust? First and very very important, intention. मेरी नियत, why I want to create this trust, what is my thing, moral है, social है, pressure है, क्या है, क्यों करना है. Second is purpose, my object, कि I want to do this to provide for my family in these areas. I want to do this because I want to protect a minor child. I want to do this because कोई child dependent है, इट्स वो चाइल्ड को abnormalities है, उसको प्रोटेक्ट करना है, या मुझे ये फैमिली डिस्प्यूट से बचाने के लिए करना है, या मुझे मेरी वाइफ को सिक्योर करना है. मेरा एक ऑब्जेक्ट होता है कि मुझे वेल्थ पास ऑन करनी है, मुझे ये करना है. दैट हैज टू बी द पर्पस ऑब्जेक्ट. Secondly, or thirdly, most important is beneficiary. Who will be my beneficiary? I cannot say to every member in my family. वो बहुत एक random हो जाएगा. I have to note down the persons जिसको मुझे pass on करना है. X, Y, Z, etc. Obviously, वो relative होना चाहिए. That they will cover on Friday कि वो एक settler and beneficiary relative होना चाहिए income tax के अंदर. But I'm saying that relative beneficiary has to be defined. अभी मुझे अगर wealth pass करे तो मुझे define करना है. I have to pass it to Mr. A, Mr. B, Mr. C. I cannot have a random कि ये सब लोग मेरे फैमिली मेंबर्स हैं, इनको मैं बेनिफिशियरी बना सकती हूँ. नो, आई हैव टू आइडेंटिफाई माई बेनिफिशियरी. फोर्थ इंपॉर्टेंट थिंग इज ट्रस्ट प्रॉपर्टी. What property I want to give in the trust? If I want to give an immovable property, but at the same time, no, मुझे नहीं देनी है. 2 फ्लैट है मेरे पास, 2 फ्लैट, फ्लैट A B. I have to be sure I have to park which property in the trust. Property A, property B, or both. That clarity I have to write, and that has to be documented in the trust deed. If it is shares, I cannot say I'm passing all my shares. I have to name each share. I hold X shares, 10 shares of Tata Power, that etc. तो ऐसे मुझे लिस्ट डाउन करना है, उसमें से भी मुझे आइडेंटिफाई करना है. And it is not a compulsion that I pass everything. Whatever I want to pass for the benefit of the beneficiary, मेरे को जो देना है मेरे साथ, मैं वो कर सकती हूँ. Then fifth important thing is कि ट्रांसफर ऑफ प्रॉपर्टी अंडर द ट्रस्ट. मतलब दैट प्रॉपर्टी हैज टू गो इन द ट्रस्ट. आई कैन नॉट बी द होल्डर माई सेल्फ एंड कीप इन द ट्रस्ट. मुझे वो पास करना है इधर. वो क्या करना है उस प्रॉपर्टी का. आइदर आई एम द ट्रस्टी ऑफ दैट सेम ट्रस्ट. सपोज नाउ इन माई एग्जाम्पल आई हैव क्रिएटेड ट्रस्ट फॉर माई ब्रदर. मैंने मेरी मम्मी को ट्रस्टी बनाया था. नो, आई कैन ऑल्सो बी अ ट्रस्टी एंड आई विल डिसाइड कि एक बार ये प्रॉपर्टी आ गई तो इसको कैसे यूज करना है, इसकी इनकम का क्या करना है, वो मैं डिसाइड कर सकती हूँ. और इफ आई हैव क्रिएटेड अ ट्रस्ट, माई मदर इज अ ट्रस्टी, देन मेरे को इंस्ट्रक्शंस लिखने पड़ेंगे कि ओके इन 2028 आप प्रॉपर्टी बेच देना, अगर आपको रेंट एक्स अमाउंट से ज्यादा आ रहा है तो आप रेंटल पे रखना. वो इंस्ट्रक्शन मुझे ले डाउन करना पड़ेगा. So, in simple terms, there are four certainties that must exist. One is intention. Why I'm creating a trust? Object. मैंने क्यों किया है ये? मेरे beneficiary कौन कौन है? I cannot have a random thing. All the members of my family are the beneficiaries. No, I have to identify my brother, my sister, my mother, my father कौन है? And secondly, how do I want to transfer the property? And secondly, what property I have to transfer? So these are some of the essential elements of forming a trust. Before I form a trust, मैं एक trust execute करने के पहले बैठ के ये सब decide करूंगी and then I can obviously form a trust. Then we come to another section, subject matter of the trust. What can be a subject matter of a trust? So suppose if there is a trust which I have created and उस ट्रस्ट में मेरा भाई वापस बेनिफिशियरी है एंड जो भी उस एसेट मैंने ट्रस्ट में ट्रांसफर किया है उससे जो भी अपसाइड आएगा, इनकम आएगी, डिविडेंड आएगा, रेंट आएगा, अगर शेयर्स है तो वो सब ऑब्वियसली बेनिफिशियरी के पास पास में जाएगा. दैट इज अ क्लियर सेट मैकेनिज्म. सो व्हाट आई कैन पास, आई कैन पास immovable shares, cash, etc. What I cannot put in a trust is a mere beneficial interest. Like suppose आज मैं एक ट्रस्ट की बेनिफिशियरी हूँ, सपोज एक मेरे फादर का ट्रस्ट है, मैं उसमें एक बेनिफिशियरी हूँ कि मेरे पापा के ट्रस्ट से समथिंग आई विल गेट, दैट इंटरेस्ट आई कैन नॉट पार्क इट इन द ट्रस्ट. वो सेक्शन 8 कंपनीज एक्ट का बोलता है कि प्रॉपर्टी विच इज केपेबल ऑफ बीइंग ट्रांसफर्ड, that beneficial interest is not capable of being transferred. Otherwise, whatever immovable property I have, that I can transfer. A lot of times, a lot of people ask us कि आप इंश्योरेंस पॉलिसी ट्रांसफर कर सकते हैं कि नहीं. अगर मैंने एक लाइफ इंश्योरेंस पॉलिसी ली है, whether I can transfer that, my view is आप उसको ट्रांसफर कर सकते हैं इन द ट्रस्ट एंड देन जो भी आएगा वो बेनिफिशियरी का होगा. दैट इज ऑल्सो अ पॉसिबिलिटी. अ लॉट ऑफ टाइम्स पीपल आस्क दैट अगर मेरे पास आज शेयर्स है, मैं शेयर ट्रांसफर नहीं कर रही, मैं राइट ट्रांसफर कर रही हूँ कि अगर डिविडेंड आया तो वो ट्रस्ट लेके जाएगा कि नहीं. यू कैन डू दैट बट देर विल बी एडवर्स इम्प्लीकेशंस. जो इनकम होगी वो सेटलर के हाथ में ही टैक्स होती है. तो ये दो तीन चीजें हैं जो ग्रे एरिया है, जो सेटल्ड नहीं है. बट अदरवाइज एक्सेप्ट फॉर मी होल्डिंग इंटरेस्ट इन अ प्राइवेट ट्रस्ट विच कैन नॉट बी ट्रांसफर्ड इन दिस एग्जिस्टिंग ट्रस्ट, क्योंकि वो ट्रांसफरेबल नहीं है. बाकी एनी एसेट्स कैन बी अ सब्जेक्ट मैटर ऑफ अ ट्रस्ट प्रॉपर्टी and can be transferred in the trust. Secondly, most importantly, who can be the beneficiary? Every person, section 9 में ये दिखाया हुआ है, लिखा हुआ है, every person who is capable of holding a property can be a beneficiary. Individual, minor, company, partnership firm, a legal person, any other legal person who can be like a trust can also be, एक private trust भी beneficiary हो सकता है. Anybody on the earth who is capable of holding can be regarded as a beneficiary in the trust. It can be a partnership firm, it can be an LLP, anybody can be there. Even multiple class of persons, like suppose अभी A है, A के बच्चे, बच्चों के बच्चे, they all can be also added as a beneficiary. There is one important point here which I want to highlight, which is very certain, which is very obvious and we miss out, is there is a disclaimer in section 9. That disclaimer says that if I'm a beneficiary, today my brother is a beneficiary in my trust. For some reasons he says कि मुझे नहीं बनना है beneficiary. I don't want to. एक फॉर्म होता है, उसको भर के देना है और उसको ट्रस्टी को, इन माई केस माई मदर इज अ ट्रस्टी, उसको ट्रस्टी को ये बताना है कि आई रिनाउंस माई बेनिफिशियल इंटरेस्ट, आई गिव अप माई बेनिफिशियल इंटरेस्ट. तो दैट इज ऑल्सो पॉसिबल. दैट इज एन एक्सप्रेस रिनाउंसिएशन. एक्सप्रेस उसने मना कर दिया, बॉस मुझे नहीं बनना है, तो आई विल नॉट बी द बेनिफिशियरी. दैट इज अ एक्सप्रेस वे ऑफ मेकिंग इट. देयर इज अनदर वे, इम्प्लाइड. इम्प्लाइड मतलब क्या? इफ ही डज सम एक्ट विच इज इनकंसिस्टेंट विद लॉ, या फिर if there is some act which if I have laid down some rules कि the trust has to do this, trust has to do that, and my brother who is the beneficiary, who does something which is completely against that, then impliedly he will not be a beneficiary. So this is a right of renunciation which is there if I want to not be a beneficiary, and he can stop being a beneficiary in the trust in this way. The next important one is section 77, which is a trust how extinguished. We will come to whether trust can be perpetual or not. We will come to that. But if there is a trust, and if I want to end the trust, extinguish the trust, stop the trust, बंद करना है trust को, तो legally कैसे कर सकते हैं हम? A trust can be full extinguished if the purpose is completely fulfilled. For example, if Mr. A has created a trust, उसने आज अपनी बेटी की पढ़ाई के लिए ट्रस्ट बनाया है कि मेरी बेटी MBA करने तक मुझे फंड चाहिए, मैंने ये ट्रस्ट में डाला है. Mr. A's daughter is a beneficiary. Her education is complete. She has 2-3 degrees. So at that point in time, I will say that trust का जो object था या purpose था बनाने का वो complete हो चुका है. Trust can now be extinguished. Trust when it becomes unlawful. Now today, suppose for example, betting is legal. I can bet. And मैंने ट्रस्ट उसके लिए बनाया कि ये शेयर्स डाले हैं, ये फ्रेंचाइजी राइट्स है, मैं बेट कर रही हूँ शेयर्स के ऊपर, या ये मैं बेटिंग कर रही हूँ, ये कर रही हूँ. It is legal. But tomorrow the law changes and they say that betting is illegal, assuming, then also that trust becomes illegal because now the activity of the trust is unlawful. थर्ड इज कि अगर मैंने ट्रस्ट के अंदर एक प्रॉपर्टी डाली है या एक पर्पस की कुछ डाला है, सपोज मैंने एक प्रॉपर्टी डाली थी ट्रस्ट में एंड दैट हैड टू बी यूज्ड, जो रेंटल था दैट हैड टू पे द बिल्स ऑफ माय फैमिली मेंबर्स, बट समहाउ द प्रॉपर्टी व्हिच आई हैव पुट, दैट प्रॉपर्टी इज अ गवर्नमेंट acquired property now. I cannot do anything. And that property has gone. It's not possible for me to reclaim anything. So I cannot fulfill only. मैं वो कुछ काम ही नहीं कर पाऊंगी. Purpose only of the trust of using the property is not there. So at that point in time, the trust can be destructed. And fourth and most important is revocation. If there are two things, जब मैं ट्रस्ट की वो डीड बना रही हूँ, चार्टर बना रही हूँ, इफ आई मेक अ प्रोविजन that okay, in this event, like suppose if I put till my brother becomes age of 70 or till my brother dies, once he dies the trust can be stopped, revoked. मैं एक एक्सप्रेस कंडीशन डाल सकती हूँ, या टिल द प्रॉपर्टी इज सोल्ड द ट्रस्ट विल रिमेन. तो मैंने कंडीशन डाली, तब तक मेरा ट्रस्ट इन फोर्स रहेगा. द मोमेंट वो कंडीशन फुलफिल हो गई, ट्रस्ट रिवोक हो जाएगा. एक्सप्रेसली मैंने वो कंडीशन डाली. तो अगर अदर देन दैट इम्प्लाइडली कुछ हो गया, जैसे मैंने कंडीशन डाली नहीं, मैंने एक ही प्रॉपर्टी आज ट्रस्ट में सेटल की, पर मैंने कंडीशन ही नहीं डाली, वो प्रॉपर्टी बेच के इनकम भी डिस्ट्रीब्यूट हो गई, तो ट्रस्ट में कुछ है ही नहीं, तो इम्प्लाइडली ऑल्सो ट्रस्ट कैन बी रिवोक्ड. It's a very important provision because at times in Indian families, in our ancestral properties, we have seen that trust comes from 4-5 generations. अब property trust में पड़ी है, trust का law, trust के beneficiaries नहीं रहे, settler नहीं रहा, trustee नहीं है, property how do you take it out? Property बाहर कैसे निकाले, पास कैसे करें, इनकम कैसे यूज करें, ट्रस्ट बंद कर सकते हैं, कब बंद कर सकते हैं, कब क्या क्या इवेंट हो सकता है. सो वेरी इंपॉर्टेंट प्रोविजन इन द ट्रस्ट एक्ट. Second is investment. Now we all know that if we have put money, we have put shares, we have put property, we will not let it be idle. Trustee will have a power that, okay, I can multiply the trust property, I can invest, I can put it to better use, but I can earn income also, right? That is permitted. So what all can you put in what all investments it is permitted to invest in a trust? So one is that you make a trust deed, you write ki okay, I can invest in mutual funds of HDFs, I can invest in gold bonds, I can invest in sovereign gold bonds, I can invest in this. You can have a charter. The other thing is there is a notification of the central government, that circular is there 619 करके, उसमें specify किया हुआ है XYZ, जैसे government securities, guaranteed securities, units of debt mutual funds, Basel Tier 3-1 bonds, infrastructure related debt instruments. All these instruments you can do it. So what does it mean? Either if you don't write anything that what all you can invest in, then the trust has to only invest in these securities which is mentioned in section 20 read with circular 619. If suppose आपने कुछ डाला ही नहीं, भूल गए, तो you have to do this way. If you have put, no, I can invest in these things, and all the consent of life beneficiary hai ki bhai, okay, we can do it. And then option two, if those lines are exhausted, then this, then you can invest in any other security that you have put in the trustee. So this is again a very relevant clause in the trustee. And this ensures that the income is generated. There is a preservation of your trust property. Also, the trust deed has to say the priority. Priority meaning what securities I have listed first, that मतलब मैंने जो जो इंस्ट्रूमेंट्स बोले आप पहले उसमें इन्वेस्ट कर लीजिए, जो बचा है इफ यू वांट टू देन यू कैन गो एज पर द डेफिनेशन ऑफ सेक्शन 20, वट एवर नोटिफिकेशंस आर देयर, दैट यू विल हैव टू पुट इन दैट. There is also one important thing here is that the life beneficiary. Suppose if I am a beneficiary for my lifetime, then that person has to be competent to contract, एंड मुझे ट्रस्ट की प्रॉपर्टी मिलने वाली है. अगर मुझे पता है कि मुझे ट्रस्ट में प्रॉपर्टी मिलने वाली है, मैं लाइफ बेनिफिशियरी हूँ, then the trustee will need my consent to invest. This is a proviso, a small proviso, that if I am a life beneficiary, मतलब मुझे पता है मैं लाइफ लॉन्ग रहने ही वाली हूँ एंड प्रॉपर्टी में से इतना हिस्सा मेरे पास आने वाला है ट्रस्ट की, देन ट्रस्टी मेरे कंसेंट, मतलब मैं बेनिफिशियरी हूँ, मेरे कंसेंट के बिना ये प्रॉपर्टी इन्वेस्ट नहीं कर सकता है. एक स्मॉल प्रैक्टिकल एग्जाम्पल आई वुड लाइक टू से जस्ट टू मेक द अंडरस्टैंडिंग क्लियर. सपोज एक ट्रस्ट है, उसके पास 50 लाख रुपया कैश है. अभी हाल फिलहाल आई डोंट सी एनी इन्वेस्टमेंट टू बी मेड, मतलब आई कैन नॉट इन्वेस्ट इन अ रेसिडेंशियल प्रॉपर्टी, कमर्शियल प्रॉपर्टी. तो व्हाट डू? मैं गवर्नमेंट की सिक्योरिटी में इन्वेस्ट करने जा रही हूँ. मैं 50 लाख लेती हूँ, मैं गवर्नमेंट की सिक्योरिटी इन्वेस्ट करना चाह रही हूँ. बट मेरा जो ट्रस्ट है, माई ब्रदर इज अ लाइफ बेनिफिशियरी, एंड वॉट एवर इज इन द ट्रस्ट, इनकम, कॉर्पस, एसेट सब उसका है. तो एज अ ट्रस्टी, मी और माई मदर, हुएवर इज अ ट्रस्टी, उसका परमिशन कंसेंट लगेगा टू इन्वेस्ट इन दिस गवर्नमेंट सिक्योरिटी. सो स्मॉल प्रोवाइजो, वेरी इंपॉर्टेंट एंड वेरी वेरी नेसेसरी. नाउ आई वुड लाइक टू से यार कि इस केस में जब हम एक्सरसाइज करते हैं अपना ऑप्शन टू इन्वेस्ट, द ट्रस्टी, ट्रस्टी क्यों रहता है यहाँ पे? एक तो ट्रस्ट का फंड्स प्रोटेक्ट करेगा, स्पेक्यूलेशन अवॉइड करेगा, एंड बेस्ट इंटरेस्ट अपने बेनिफिशियरीज को देने के लिए वो ये सब करेगा. तो ट्रस्टी का रोल इन दिस केस गेट्स वेरी इंपॉर्टेंट व्हेन आई हैव टू डील विद द इन्वेस्टमेंट्स. Coming to the next important thing is a trust type. What is a trust? क्या क्या टाइप के ट्रस्ट होते हैं? So firstly मैंने एक्सप्लेन किया प्राइवेट ट्रस्ट, पब्लिक ट्रस्ट, वी ऑल नो दैट. Then most important classification is specific or determinate trust versus a discretionary trust. ये मोस्ट इंपॉर्टेंट ट्रस्ट का क्लासिफिकेशन है. आपका टैक्स, आपका लॉ, आपकी ड्राफ्टिंग, आपका सब कुछ इन दोनों चीजों पे हाथ है. वेरी इंपॉर्टेंट, स्पेसिफिक एंड डिटर्मिनेट. एंड डिटर्मिनेट
दिखाए तब ना.
हाँ, सॉरी.
No, no, please continue.
So very important is the specific or determinate trust, as the name suggests. Another is non-specific discretionary trust. So specific trust, as the name suggests, है, सब कुछ specify हो जाएगा, determine हो जाएगा. Discretionary में things will be left to the discretion. So first I would like to go to the specific, determinate या non-discretionary trust. इसमें what happens typically is that there is a trust, the settlor is there, and there is a beneficiary. Settlor wants to have the full control. So today, if I am the settlor, I am putting, say, immobile and property shares, etc. I am putting cash also. So today I want to keep the right or authority बोल सकते, control you can say for simple language. Today I have the control to distribute what, to whom, and how much. So for example, in my case, again I am the settlor, my brother, my mummy, my mother, and my father are the beneficiaries. I will retain a control, or I will have the authority to say my father, mother, and brother will get house, who will get say investment, who will get cash. And if I want to say ki no, house is very big, my mother and father will get it 30-30, 50-50. That is also possible. इन अदर वर्ड्स, स्पेसिफिक ट्रस्ट में आपके जो बेनिफिशियरीज है जिसके लिए ट्रस्ट बनाया है वो डिफाइंड होंगे. उनको कितना शेयर, हाउ मच शेयर हैज टू गो, व्हाट proportion it has to go of the share, of the income, of the cash, of the immovable property, that is also decided. So in short, in other words, you can say that in this case, trustee has no authority, no control. The settler only defines everything. In this case, a simple thing can be said that no, trustee has no power. Settler only will decide everything, and settler will say that I am in full control of what has to go to whom. When you make a trust deed, हम जब ट्रस्ट डीड चार्टर टर्म्स एंड कंडीशंस बनाएंगे, हम उसमें ये सब चीजें लिख देंगे. एक्स वाई जेड बेनिफिशियरी है, किसको कितना क्या मिलेगा, दैट ऑल इज ऑल्सो रिटन इन दिस केस. The taxation, which will be dealt in the subsequent lecture, is under section 161. How it will be taxed, that they will cover there. Section 161 of the Income Tax Act, the section is covered. And trust deed plays a very important role. Again, once again, like to reiterate, control is in the hands of the settler as to who will get what and who will be the beneficiary. Trustee technically will have no power except for distribution and executing the distribution. Suppose if I want to distribute today, आज करना है, जब ट्रस्ट डिसॉल्व होगा करना है, या सब्सिक्वेंट स्टेज पे करना है, all that is also in the hands of the trustee. Very important mechanism, specific trust of dealing with the trust, and very relevant in today's time and age. And the tax implications are also very relevant in this case. Coming to the next bit of it is okay. Is my screen visible? Is my screen visible?
Yes.
Okay. So coming to the next one is a discretionary trust. Discretionary trust is a non-determinate trust, you can say it. What happens in a discretionary trust? Completely opposite of specific trust, one way. Today I make a trust where the settler is there and there are 3 children. I settle shares, assets, etc., cash, etc. But today I don't decide the proportion. Who will get what? Income. Suppose if the property earns 1 crore rupees today from rent, which child will get how much income? I have not decided. Suppose I want to distribute the property. मुझे आज बोलना मैं अभी cash distribute करूँ. Which child will get what is also not required, is also not documented today. At that time when I'm making the trust deed, I will only write this is the beneficiary. A, B, C, child A, child B, child C. I will not write who will get what, in what proportion one will get. This is called a discretionary trust. Things are not defined, not discretion, they're not defined, not determined. Question is who decides? The trustee decides in this case. The trustee plays an important role. Control is with him. He will say who will get what proportion. He can discuss with the settler, but the settler will not have any role after the property is settled. So trustee will have the power, trustee will have the right to determine who will get what proportion and how much of income, how much of asset, and when it has to take place. Generally, in a family trust, when you're dealing with a closely held family, family offices, a discretionary trust, in a discretionary trustee is a family member only. Suppose if today I'm creating if there's a trust created by Mr. A, the settler in our case, the settler, his brother, his close friend, his wife, his mother, or his younger brother, somebody of that sort can be the trustee who has a rational discretion, who would exercise his rational discretion to decide, and then that person becomes the trustee. Suitable cases, this trust would be suitable in cases where beneficiary is a minor or with somebody with a disability, or you know that you are going to have a huge proportion of gain. In those cases, it's suitable that you make such a trust. And possibility that the other beneficiary, there can be one more possibility that today the settler has said that X is a beneficiary, minor child C. The trustee has a power to add one more beneficiary. Say there is one more child, there is some other relative of the settler. Trustee can admit that person also as the beneficiary. Why do we have such trust is it gives a greater flexibility to take decisions. You have a flexibility to take decisions. Trustee can also exercise the power to say that, okay, child C is behaving nasty. I want to remove him. He cannot be a beneficiary. Or I feel that there are two children, but I want to add the mother as the beneficiary of settler. So that is also a possibility, and you can add that. That flexibility is there with the trustee in a discretionary trust. When you're drafting the trust deed, you only write the name of the beneficiaries A, B, C. Also, you can say that trustee has the power to add X as the beneficiary or Y or somebody else who's a family member or lineal descendant of the settler. The provisions of taxation of discretionary trust is covered under section 164 of the Income Tax Act. How to tax and the controversies and what are the tax effects that will be covered. So these are the two broad classifications: specific trust, discretionary trust, where you identify, define, and in one case you don't define. Moving on, the another discretion is a revocable or a irrevocable trust. Very interesting. This concept is purely from an income tax perspective, but I would just like to cover it in brief so that we understand the concept. So as we saw, specific and discretionary trust is based on the decision that who can be the beneficiaries, whether the share is identified or not. So what is a revocable trust? So first is revocable. The settler. Suppose if I'm the settler, in many cases, I'm also become the beneficiary. I will say I've settled property. I also want the income. So I will become the beneficiary with others, my mother, father, brother, everybody. So what happens is whatever the trust gets the income, I have not parted with the income. The income comes to the trust, but somewhere or the other I'm going to receive it. Right? That income will come back to me only. That particular phenomena is called a revocable trust. What happens is in that case, I have a right to take back the asset or the property or the income to my hands. That is a revocable trust. It is taxed in the hands of the person who's settling. Section 61, taxed in the hands of the person settling. Typical case of a revocable trust. Your trust deed also provides that. Why I do this? Because I don't want to give the control. At the same time, I want to have the benefit of the income also. The next important thing is irrevocable. So I have settled and trust, but I don't want the income, I don't want the asset, I am not the beneficiary. So this is an asset protection method, and therefore I can do that. That is an irrevocable trust. In that case, what benefit I get is that once I have settled a trust, suppose today I have settled the trust, I will never get the assets back. Once the trust is settled by me, whatever assets I have transferred, that assets cannot come back to me at all. It will go, if at all, to the beneficiary who is defined in the trust. So that is an irrevocable trust. The asset or the income doesn't come back to the settler. It is a permanent asset protection. There is no estate duty if and when resurrected, and also it's very advantageous from tax perspective. And the control is with the settler himself. It is possible to set up a revocable or irrevocable trust. The third category is a deemed revocable trust, which is not mentioned here. It's a funda of tax, but just covering it so for our understanding. At times, what happens is your instrument will not say that it is deemed revocable. But if there is some income generating and there is a provision that income comes back to you as a settler, or that asset can revert back to you in case of some event, that is a deemed revocable. You are not the beneficiary, but you have mentioned in the deed or by some act that income comes back to the settler. That event is a deemed revocable, and in that event, everything gets taxed in the hands of the settler. That is laid down in section 63 of the Income Tax Act. Very important concept. Very often we miss it out. It is possible that in the deed of trust you never write also that you will get the income, that you will be a revocable or deemed revocable. But these actions of yours can make the trust a revocable, irrevocable, or deemed revocable, and the tax implications would accordingly follow. Coming to the next one, very important again, testamentary trust or a will trust as it is called. What happens is in these cases, In normal cases, suppose if I have to make a trust, I make it under a deed of instrument. The person who's transferring the property, called as settlor, he transfers the property. Everything is done during his lifetime. So if I'm alive today and I transfer my property in a trust and I transfer X property, I create a trust today. I create a trust today and keep, and I say after 10 years the property will be transferred. All this is a normal trust procedure. There is one step ahead where I make a will. The person who makes the will is called the testator. The person who makes the will says that under my will, I will create a trust. I make a will. Once I create a will, under a will, there is a trust created. And that particular trust is called a testamentary trust. The term is testamentary trust. So I can put in my will only, I will put that, okay, XYZ will be the beneficiary, this person will be the beneficiary, this person will not. Any person who's above the age of 21 can make this. It has to be signed by, because it's a will, it has to be signed by 2 witnesses. And in this case, the assets and the income, whatever you do, you want to distribute, that will be distributed as per my wishes. Now, the person who prepares a will, in legal language, he is called a testator. So the assets and income will be going as per the wills of the testator. And these are my wishes which will be fulfilled after my demise. As we all know, will comes into play after the death. So a testamentary trust or a will trust will also take place after the death. So suppose if Mr. A has made a will, in that will there is a trust which is declared. The trust A will be made, my wife and my 2 children will be the beneficiaries. On his death, when the will is executed, that trust will also come into effect. And the property will pass at that point in time. So it's a classic example of a passing of property under a will and making a trust under a will. One important thing is you don't need a separate registration during the lifetime. Because you have not created a trust in the lifetime, you have made a will. And not affect you, this trust doesn't come into play during lifetime. It is not effected during the lifetime, so you will never be able to see the distribution of property. You can make n number of changes to a will. There are 2 ways of doing it. Either I rewrite my will, cancel the old will, rewrite the will, or there is a document called codicil by which I can amend my existing will. So by these 2 documents, I can make a will, change the will, and make this trust. Post the death of the settlor or the person making the will, and the property passing, the trust becomes irrevocable because the person who's made the will and the trust under that is no more. So the property or the income never goes back to him. So this is, in a way, becomes an irrevocable trust. It is beneficial for some important things for minor children, relatives with disabilities, or you know that you are going to inherit a large sum of money. In those cases, this type of trust becomes important. And in case of a minor, you appoint a trustee because minor is not capable of taking decisions. If minor is a beneficiary, trustee is appointed to execute. And there is a drawback is that you don't get immediate asset protection. Suppose if I want to protect my assets today and I create a will and a trust inside that, then I don't get an asset protection. So this is a drawback of testamentary trust. Otherwise, it is a very good instrument. If I want to pass on the wealth on the death and under a will, so it serves as a very, very great instrument. Secondly, it goes as per the will of the person who's making it. Testator, you can call it. It goes as per the will. But mind well, a will, when it is written, it can be written in any format, but there have to be 2 witnesses to sign and execute the will. So if I'm creating a trust also under a will, when I'm writing my will and I've created a trust, that same procedure of making a will, of signing, attestation, etc., attestation or signing is required. One more important thing, which I thought I'll just cover it here, is now there is an amendment and our wills no longer require a probate. Wills compulsory don't require a probate. There are some states which require, but there is an amendment, wills no require probate. So even if I'm making a trust under a will now, the probate thing is not a requirement and it can be made without a probate also, this will. So that law would equally apply to these cases as well. Now, some essential things when I'm drafting a trust deed, the very important, what do I put, etc., how does it work, etc. Very important because trust deed is the most important document I feel which needs to be there. Some just general points, not getting into the basics. That when you draft a trust deed, there is no particular format. There is no big format or big legal language. You can draft it in any language, your local language, Bengali, Hindi, Gujarati, Marathi, English, any language. There is no particular format. Trust deed is just to reflect your intention meaning what I want to pass, whom, etc. Secondly, you don't when you're drafting a trust deed, you don't need to use legal jargons or technical words. It can be in same plain English, but it can at the same time it cannot be ambiguous. It cannot have one asset given to two people or something like this property is here and there and then I'm passing. So the language is has to be very clear. Like it cannot be confusing. Like I have four properties, I don't have four properties, something like that. So practically, when you draft a trust deed, you have to identify the beneficiary, what asset. All this has to be documented in the trust deed. Language has to be simple, clear. You don't need to use big legal jargons. It can be any format. It can be written. It can be any formatted. It can be in any way you can do it. Is there? It has to be well structured and organized. Important things which are necessary, which comprise of a trust deed are statement of trust and objects. What object I want to put? What is the trust for? Beneficiaries, naming them. List of properties, very important. Along if there is a plot, if there is a building, fatta number, plot number, area, etc. Very important. Mechanism of distribution. If I am the under a specific trust, how I want it to distribute. Types of trust. I want to make a discretionary trust, specific trust, intention, and very importantly, how do I distribute the trust on dissolution? What and how I will distribute, and how will the trust get dissolved? Very important thing when we plan a trust. So we have to have all those pictures. You can also have the working area of the trust. For example, if I want that the trust only does investment activity or it does some kind of activity like renting of property, I can put that. If it wants to have some object like it, the trust can invest in a property which is located in my ancestral town. Like if I have a town which is in Delhi, I'm in Bombay, but I want the trust to only invest in a property which is in Delhi, in my ancestral town, I can do that. Or if I wanted to operate across India and do it, I can do it. If I don't want my trust to operate and acquire shares in some company, XYZ company, I will never acquire. I can put that down. That can be the working area of the trust. One vital part is the object. What is the trust made for? Benefit of which person? What can be the support? What it is not that the law, the object of the trust cannot be unlawful. Like I am making a trust which will earn money out of killing of leopards. So these things which are prohibited by the law, these things cannot be a party of the trust object. If I make such a trust, so if I'm made out of ignorance, then this trust is void. It is not regarded as a valid trust. It is cancelled. It is not a valid trust because the purpose is unlawful. I cannot have a trust where my purpose, as per the prevailing act in India, is unlawful. This is not there. Generally, you make a trust why you want to provide medical support to your relatives, educational support, marriage funding, all that. So this is very important. Another is trustees, the duty and the power. You have to have the trustees' roles defined. That what they can do. They can vote in which properties. They can have a say in what things. If there is a family member who's a beneficiary and the trustee doesn't get along, then what are the powers? How much he's willing? If somebody is not willing to act as a trustee, what has to be done? All these things. Then another important clause, a dissolution clause. When and how can the trust be dissolved? In what circumstances? Object fulfilled, etc. Another important thing is when you draft a trust deed, the trustee and settler signature and the witness's signature is inevitable. My well drafted trust deed has to have the signature of two witnesses, trustee, settler, everybody, and then only a trust is regarded as a well drafted trust deed. And these are some basic elements which are very, very important when you draft a trustees and which are necessary in today's world to keep in mind when you're drafting a trustee. And these are the general formats of the trust which I have explained. Some ancillary documentation which you may keep, like if you wish to make a trust, is a declaration that settler has to declare that I am making a trust, which property. Bank account opening, you will need a trustee. PAN application also, you need a trustee. You need titles and certificates that, okay, today if I'm settling a property, say, and that property is under the bank mortgage or it's under a lien, that has to be a title to say that the property is clear of all this. Is consent acknowledgement of the trustee. If I have to act as a trustee, I have to give my consent that I will be acting as a trustee. It helps in bank regulations and giving to the regulators, SEBI, etc. Document for KIC, etc. Very important is a schedule annexure
वो
of
एक
the
एडवोकेट
assets.
रोजीना का फोन दिया है, वो जो मेरे को ये की हो ना, ये उसको व्हाट्सएप कर दो तो सब, ये जो डाउनलोड की हो सारा आप भेज दो ना। हेलो।
Siddharth, any query or should I
No,
continue?
no, please continue. I guess one of the members got unmuted by mistake. So
Okay,
I
okay.
just
I
thought
thought
that
there's
it's
some query.
something.
Okay.
No,
So,
no.
whatever assets I'm transferring in a trust, there has to be a schedule saying this is a trust corpus which has each asset, immovable property, cash, etc. I have to write the value. Not necessarily I have to write the value, but if possible, if I want to write, I can do that. If not, I can list my assets. I can put the share. If I have shares, I can put the number of shares, the company. I can put the description of the immovable property. I can put the gold, etc., etc. All this I can put in a schedule. Very important, very necessary document. Some of the essential points to add in a trust deed is power game again, that whether a beneficiary can give a gift, who can be the settler, settler can add less beneficiary, hierarchy in the family, who can be the beneficiary. If there is a non-resident beneficiary, whether the trust can be formed. If a trust has to be formed and everybody is non-resident, whether trust can be formed in India. And whether the trust has the power to do business. Suppose if I'm transferring my property in the trust and the trust wants to do business, can me as a trustee allow the trust to do business? Do I need the consent of the beneficiary? All these points, when I'm drafting a trust deed, it is extremely essential and extremely necessary, and I need to do that. Now we come to a very, very important point, is a registration of a trust. Okay, like we all know, in India, many documents need to be registered. One important thing is a registration of a trust. Question will come to your mind whether it is mandatory or it is obligatory or it is not compulsory or it is an option. I would like to run into true legal propositions for this and then I will give my views. A trust deed by which the settler transfers the immovable property, that is land or building, from the settler to the trustees, that instrument, that qualifies as an instrument. And that particular instrument in India that creates a transfer or any immovable property requires registration. I repeat, there is a trust deed by which a settler transfers the immovable property meaning land, building, etc., from the settler to the trustee. That document, that trust deed or that declaration is regarded as an instrument, and that instrument in India that creates a transfer or right in immovable property has to be registered. I get this from Section 17 of the Registration Act of India 1908. 17(1)(b) says that non-testamentary testamentary instruments I explained, trust under a will, non-testamentary, normal trust, which purport or create or operate, declare, assign, extinguish, whether present any right, title, interest, whether vested or contingent, of the value of 100 rupees or more. Suppose if there is an immovable property which is more than 100 rupees and which is transferred in a trust deed, written trust deed, that is an instrument. That particular trust deed has to be registered with the sub-registrar under section 1908. Now, one important thing I would like to say here is that as per this act, section 28, so suppose if there is a property which is located in Calcutta in Bada Bazar, I cannot register the property in Bombay. I have to go to Bada Bazar, Calcutta. There will be a sub-registrar of that particular area and I will register my property there. Likewise, if I have a property in my office, near my office, I cannot come and register it in Bada Bazar because the registration duty is less. I have to register it in Bombay where my office is located. So that is coming from section 28. And once it is registered, now suppose today I've registered the property, you get a certificate that property is registered. That certificate is a legal evidence of the creation of trust, which is required. That comes on a trust deed. That property which is come in the trust is now the property of the trust and it is registered in the name of the trust. That's a legal evidence of creation of trust. So if you don't register a property or you violate that condition, then that transfer is not valid. That comes from 58, 59, 60 of Registration Act. So you have a requirement to register the property in the area in the location where the property is located. Suppose if I have a property in Bada Bazar, I have to register that. If I don't do that, that property is not regarded as registered in the name of the trust. That would be regarded as a settler's property only. All these comes from section 58, 59, 60 and section 28 of the Indian Registration Act. Now, if I don't register, what happens if I don't register? Assuming I have a property, मैंने trust में डाल दिया, मैंने register नहीं किया. Then in that situation, what happens? In that particular situation, that trust deed is void. It's not regarded as a valid trust deed. It's void. It's useless. It's not valid. Void. Against third parties. Matlab, suppose if I have to produce a document and say, oh, this property is not mine. It is in the trust. मैंने transfer कर दिया था. But मैंने register ही नहीं किया. तो third party meaning a bank or a lawyer or somebody who's come to sue me will regard it as my property. That trust deed itself is regarded as void. And against, like, suppose if I am the settler and my brother is the beneficiary and we have a dispute. In that case, it is voidable. The trust deed is regarded as voidable. Can be cancelled. Transfer will not be accepted. However, this is a legal provision which we do it. And if you have an immovable property, to make the transfer or make the property of the trust legally enforceable, effective, non-judicial stamp paper, you get it registered. This is under the Registration Act. Now, what does the Indian Trust Act say about this? Section 5, Indian Trust Act, it says that if I transfer an immovable property, asset is immovable property, land and building, the registration is required in writing. If I have an instrument trust deed, that is an instrument declaration or a declaration of trust, that is an instrument made in writing, I need to register if I have an immovable property and then it is regarded as valid. Again, non-testamentary will cannot be registered. Okay, will comes into effect after death. So if I have created a trust under a will, it cannot be registered. Registration requirement is not there. But if I've made a trust deed today or declared a trust, then, and it is a non-testamentary one, and there is an immovable property, you need to register it simply at all. If there is a movable property like a share or a cash or a gold, then there is no legal requirement to register. It is still valid. But practically, in practice, we advise everybody to have every trust deed registered. So, for example, if I've made a trust and only settling shares in a trust, मैंने खाली shares transfer किए उस trust में, practically I would advise my client or I would practically have the deed registered so that tomorrow that is a legal binding document against any claims, counterclaims, etc., which I may have. So this is a very important aspect which needs to be kept in mind. Now, if there is a non-testamentary trust for a movable properties, no registration is required. But obviously, on that trust deed, you will have the signatures of the trustee and the settlor, etc. So then it is also binding legal. It's valid, it's legal, it is not illegal, it's a valid legal document. It will stand the test of time. But as a practical measure, nowadays, all trust deeds get registered. This comes to another important part of rule of perpetuity, very important. So I was addressing one practical example to lighten the moment, I would say. I was addressing a seminar, a certification course of ICI, and I was asked by a gentleman whether I can make a trust for 400 years. And can my trust continue for 400 years? So I was carried away by his explanation that my grandchildren's grandchildren will be the beneficiary and the trust will be 400 years. It's valid. I said, if they're relatives, they'll be valid, but rule of perpetuity may work against you. But then the discussion didn't end, and somehow we were convinced to give a view that it will be valid. But I would like to say that a trust can never be perpetual. So when you're drafting a trust deed, when you're making a trust deed, or when you're intending to prepare a trust deed, we need to keep one thing in mind, that the trust can never be perpetual. This works against many laws in India. This works against the power of vesting and against the basic fundamentals. So a trust can never be lifelong, ajivan, amar with amrit. A trust has to come to an end. How we will see that, but a trust cannot be like the one who can be alive for years and years and years and years. The trust has to end at some point of time. So you cannot say that trust is ajivan or has amrit and can never die. A trust has to die, and this is a rule of perpetuity. So the rule of perpetuity comes from section 14 of Transfer of Property Act. It is not there in the trust deed. One legal practical point I would like to share from my experience is that when you're drafting a trust deed, now today I've drafted a trust deed, I have to put a clause as to termination of trust. I can write there that till the last beneficiary is alive, from 100 years from now on, or from 20 years from now on, or till a date where this happens. So I have to define that in the trust deed as well. It's very important that I write in the trust deed also. But at the same time, when I'm planning a trust, I can at the same time write, or I have to keep in mind that trust can never be for perpetual or for n number donkey's years. If I create such a trust, which is there for lifetime, that trust is void, not valid, void. And why do I have to do this? Why is this rule there? One may ask, what is the purpose? I'm making a private trust. I want to give to my grandchildren. आपको ये rules क्यों चाहिए? आपका requirement क्या है? My answer is, if I make a trust which is perpetual, a jivan, or you can say namrityu wala, or has amrit, whatever you call it in loose terms, it is to prevent indefinite perpetual remote vesting interest, which hinders free alienation of land and assets. So to avoid all these situations, this rule is there. It is not there in section the Trust Act. It is there in Transfer of Property Act. There are some important elements, and which first I will give you a practical example, and then we can read it. It will be very easy. So as you will appreciate, this is not an easy provision. After reading it a couple of times also, the language seems very confusing and heinous, and one cannot draw proper interpretation. I've tried my best to put it, but this section is a little tedious on us. Now I'm giving you a practical example, and then we can understand these provisions. Now assume that there is a very big person, famous personality, who has 12, 13 children. That person has created a trust today, private discretionary trust. That person says, my trust will be alive and will be created for my 11 children. So he names all his children as beneficiaries. They are the beneficiaries. उसने trust बना लिया. अब वो बोलता है कि the unborn child of my children will also be beneficiary. Today, his last son is maybe 10-year-old, 12-year-old. He's not married. He has no children. He says, till the end of life of my unborn child of my child. Matlab, today his 10-year-old son is there. When he will get married, when he will have an unborn child, till he survives, the trust will be there. This is his language in the trust deed. How does this section operate? This section says that when the trust is created. Today is 11th March 2026. I create the trust. When I have created the trust, the settlor, Mr. L, his wife, Trustee, and his 11 children are alive. Till the time all of them are alive, and till the time suppose everybody dies, and last child, जो उसका 10 साल का चाइल्ड है आज, वो 70 years के बाद 80 years का हो गया. Till the time he is alive, till the time he is alive, and there is a child born at that time. उनके ऊपर में से कोई लीगल असेंडेंट डिसेंडेंट का एक बच्चा is born at that time. Okay, suppose if today is 2026, after say 80 years, समझो 2030. 2030 में there is a child born to any of his brothers or to anybody in that family. Till the time that child is born, and that child attains 21 years of age, majority age, that trust will survive. So from now on, 100 years. How does it work? Is that when I have created a trust, any member, settlor, trustee, beneficiary, any one of them have to be alive. The person who's going to be the next beneficiary, that unborn person, it can be in the womb also, it is not born also, both is okay. That unborn beneficiary has to be born before all of them die. Matlab, everybody dies, one person is surviving, that person is born, he can be a beneficiary, but the trust will continue till 20 years after till he attains maturity. So suppose if everybody dies and the child is not born, then the trust comes to an end. If he's born, suppose this person dies in 2030 on 18th May and the child is born on 17th May, then this trust will continue for more 20 years till the child, 18 or 21 years till the child attains majority. So this is a rule against perpetuity, that they discourage trust from going on and on and on. And there has to be a limit. So practically, if I see from today, if I create a trust, till 100 years the trust can be alive. This is the rule of perpetuity, where you cannot have lifelong trusts. One may ask me, ma'am, what if we create a trust which has a company as a beneficiary? So the company never dies, company goes on. My mind, you will have to add an individual beneficiary. And then the date, again, the same rule will apply till his unborn child is added as a beneficiary. And 20 years of him becoming majority age, this rule will apply. This is a simple, clearest form which I could explain a case of a unborn child and a large family and rule of perpetuity. Let us break the elements of 14. There must be a valid transfer of property. Transfer must be for an unborn child. He has to receive full ownership. Property must first pass through limited interest owner. Means property has to go to a person who's alive at that time. And that ownership has to vet till he is the owner he knows. But he has the interest he knows. But he will be owner only after the unborn child gets the property in his hands. Only after he has majority. He has an interest. I have an interest today. I know I'm going to get in my father's trust 100 crores worth immovable property. But that will come to me only if I'm at the age of 21. The maximum delayed vesting period includes life of preceding interest holder, gestation period, minority of the ultimate beneficiary. Only these three can be the delays in the passing. And life can be, and vesting of interest in favor can be postponed only up to the life or life of the living persons. Living persons, they mean that all the people who are living today, plus if there is an unborn child, 20 years. Only till that time your trust will serve. This is a rule of perpetuity. So people who create trust for 400 years, 500 years, children's, grandchildren's, grandchildren, the trust doesn't survive that way. Person who has created the trust, person who's a trustee or person who's a beneficiary at the time of the creation of trust, and an unborn child is born in the presence of one also person. The child can be in the womb or the child has to be born. Both the possibilities, then the rule of perpetuity works in that favor and the trust can be created for that. Otherwise, such a trust is a void. That trust is not into existence. The trust can be cancelled at any point in time. Very important rule, very important while drafting, advising clients, taking advice, or making our own trusts. There is another rule of perpetuity, which is in Rule 13, again of Transfer of Property Act. this particular section 13 of Transfer of Property Act, it says that today if I've made a trust and I've transferred a asset in a trust and say that it's for my wife. After my wife, it will be for my child who is not born yet. So here the law says that property must be first transferred to a person who's in existence of the date of transfer. Suppose if I say that today this will be in the favor of wife, but I'm not married only. So then this is void. I can't do that. First level, the person to whom I'm passing the property in a trust has to be there. So if I'm married only and I have a wife, I can say I'm passing it to my wife. After that, I say if I have a son, then my son will get the particular interest. So then this works in that way. In other words, property must be first transferred to a person who is in existence on the date of the transfer. The person, now my wife has to hold a life interest, immediate interest, limited interest, any type of interest in the property. They enjoy their property in the lifetime, but they cannot alienate or dispose and get the absolute title. Interest created for benefit of unborn person must extend to the whole of the remaining interest of the transferor. Again, very complex drafting, but in simple terms, if I say, if I have to make a provision for unborn child who will get the property, today I have to make a life interest in favor of somebody who's there in existence, who's alive, make him the beneficiary. He will enjoy the property, but no title. When that unborn child is born and becomes the trust beneficiary, everything property belongs to him until he earns majority. Possession belongs to him. So there is a necessity that I create an interest today in favor of somebody and then pass it on. This is a rule of perpetuity explained in section 13 of Transfer of Property Act. This is also very important when we plan, structure an unborn child's passing of property. Now, before going to the next topic, that is trust as a legal person entity, I would just like to highlight 2-3 advantages why a trust has to be created. Just running through in brief, like rational, if somebody wants to do it, why do I do it? Or what is my need to do it? Or what is my advantage to do it, rather? It brings foresight, focuses on awareness that what mechanism is available, why I am planning, what I can get, what are the laws, how will the property pass. In today's time when everything is changing so dynamic, like today, for example, assume that somebody is stuck in UAE in the war and doesn't know whether he'll get back, make it in time, etc. So at that point in time, before that, if I've already planned my affairs, my clarity is there, then at panic stricken hours, I'm not taking hasty decisions and making wrong decisions. Secondly, when drafting or making a trust, legal framework, tax, laws, registration, stamp duty, passing of wealth is very important. We cannot ignore that. So I have to make a trust deed also and get in the ambit of all this. Secondly, if I am prone to a risk, say for example, I'm prone to some attachment or some risk, I park my property in the trust, then I'm ring fencing my loss, ring fencing my risk. So that serves as an important element. If and all, there is no absolute announcement, and I will also not endorse this fear, but if the estate duty is resurrect, it comes back, उसको वापस backdoor से लेकर आए. So trust, if I make a trust and I pass the property, estate duty will not be there because estate duty is on death, passing of property on death. I don't endorse the view that estate duty is going to come or not, but if and if it comes, we don't know. With the government making retrospective amendments in all the laws, you cannot actually know what will be the next move. Secondly, what happens is today, if there are large family houses and there are brothers' siblings, brothers' children, my children, to protect everybody's interest and to keep the momentum alive. No, you will also get, you will also get, you will also get. And if there is a specific need of each family member, I may want a money, he may want asset. In large family businesses, large sibling houses, etc. This serves as an excellent document where everything is crystal clear, classified, effected, distributed, etc. One very important thing in today's time and age with the dynamic world is marital discord. In case of any divorces happening, or if I want to protect, like we have prenuptials, if I want to protect somebody from a marital liability, I can park the fund in the trust. I can make a discretionary trust such that the husband or the wife doesn't know what he will get. In that situation, there will be no claim on that amount of property if it is in the trust. Or if there's a cross border marriage, this also serves as a very important tool. Secondly, in case of complex assets, if I have many assets, property, title, etc., gold, real estate, securities, luxury vehicles, etc., and I am not sure collectibles, paintings, etc., cryptocurrencies, aircraft, etc., I can park it here, decide the way, mechanism, response, etc. Another thing is in Indian societies where there are family businesses, we usually don't want to point out our disputes to everybody in the world. So this protects my family peace, harmony, reputation, legacy, values, so that there is no hindrance after person dies. His family is not fighting over who will get what, how, etc. Also addressing the realities of global Indian families. Nowadays, we know that children are settled abroad, investments are abroad, family businesses are run everywhere. So to protect that also, this serves as an excellent tool. So these are some of the reasons why you need to make a trust and why you can make a trust and have these reasons to protect your assets, your wealth. Lastly, my last topic which I would be covering is trust. Oh, sorry. Trust as a person, as a legal entity. So, as we all know, trust is not a legal entity. It's a concept, it is recognized, but trust is not a legal entity. Like how you have LLP, which is a recognized legal entity. So you have assessment of like LLP separately, you have tax, you have PAN, etc. And it has its own charter, it does its business, etc. Trust is not a legal entity. In section 231 of the Income Tax Act also, which defines person, in FEMA also, which defines person, trust is not recognized. Mind well, trust is not an item there. So if you see the person's definition in Income Tax Act or FEMA, you will not have a separate entry for trust. What do you mean? The trust is not taxed? No, the trust will be taxed. Trust can be taxed in two ways, as an individual or as an association of persons. Either way, it can be taxed. If it is an individual, it will be taxed in individual rates. If it's an AOP, AOP becomes when there is a business carried under a trust, it is regarded as an AOP, and accordingly the trust will be taxed. Second important thing is, in case of a trust, trustee is taxed as a representative assessee. A trustee of a trust is taxed as a representative assessee. So to that extent, to my mind, trust is not a legal entity and not a person under the Income Tax Act. Charitable trust still has a legal existence of its own, but a private trust would not have. If there are different types of beneficiaries, suppose say there is an individual, there is a company, there is a trust, etc., then status of the trustee becomes relevant, individual, AOP, etc., and accordingly, based on discretionary specific, you can tax the trust. All that, whether what is the status of a trust, whether trust is a person, individual, AOP, how it is taxed if it's an individual, how it is taxed as an AOP, and what is the residential status, etc., of a trust. And you have to see the status of the trustee, the beneficiary for taxing a trust, etc., would be covered on Friday, I'm sure. But this is just a basic that trust is not a legal entity. There are some two case studies, which is just a format which I've tried to put in. There's a settlor and he's made a revocable private trust, and there are two beneficiaries and his friends are the trustees. Trust deed provides the trust will terminate upon the beneficiary reaching the age of 30 and corpus will be divided equally. This is a typical irrevocable private discretionary trust. Trustee can invest the trust, distribute the income equally, etc. This is a specific trust because income is divided equally. Similarly, there is another trust where trust would be dissolved if both the beneficiaries attain 25 years of age, and the trustee can sell the factory, corpus, etc. can be dissolved, and this is a specific trust again, and this is how you can form a trust and execute the trust. Yeah, So happy to take up any questions.
Ma'am, we had one question about stamp duty implication if we transfer a property.
So essentially, the stamp duty, the stamp duty is applicable on settlement of a trust or declaration of a trust. The moment I declare or settle a trust, I have to pay the stamp duty applicable on the instrument of the trust. Secondly, when I'm passing any property under the trust deed, that is an movable property, your Indian Stamp Act provides that 3% of the value of the property has to be paid as a stamp duty on immovable property, and some 5% or 3%, and then 3% has to be paid in case of a movable property, and that to the fair value of the property has to be done. Then you get the value of the immovable property, make a 5% stamp duty payment. I'm not sure about the individual states, but Indian Stamp Act definitely provides, and Maharashtra Stamp Act provides about that. And if it's a share or something, then 3% of the market value of the property has to be done. So stamp duty is required when you are making a trust.
So, ma'am, if
Mind
we
health?
trans-
Sorry. Just one more point here. Since
yeah,
if you make a will, under a will, if you're passing any property, suppose if there is a will and I pass my property to somebody, there is no stamp duty there. That is the difference. Yeah. Yes, Siddharth.
no, ma'am, if I transfer a property to a trust and thereafter it is transferred from the trust to my descendant, will the stamp duty will be applicable twice?
No, 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 no. Stamp duty is applicable only at the first stage when I introduce the property in the trust. When the trust is distributing to the beneficiary, that is a working out of rights. It's a working out of rights, it's a distribution. There is no stamp duty at that stage, only when I'm transferring in the trust.
If there are any other questions, members can unmute and please ask, ma'am.
Your voice is breaking.
If there are any other questions, anyone can ask.
Good evening,
Yeah,
ma'am.
hi.
Good evening, ma'am. I have one question. Like you said, in under Section 20 of the Indian Trust Act, we can make an investment as per the provisions laid down under Section 20 of the Indian Trust Act. And if nothing is written in the trust deed, then we cannot make the investments as per our wishes. So kindly, give your inputs more elaborately on this point.
Suppose today you make a trust deed. Okay. You don't write anything. You say you don't write anything on the investments. You have a surplus in the trust. You don't want to keep it idle. Obviously, I assume. So then what happens is Section 20 of Indian Trust Act, and there is a circular, you can note down 619. Okay. That gives you 5 to 6 list of securities. X, Y, Z, like mutual fund of government, bond of government. You can invest that fund only in that. बट आई एज अ इंडिविजुअल आई विल से दैट नहीं यार एफडी में करते हैं ज्यादा पैसा इंटरेस्ट मिलेगा आई वांट दैट फ्लेक्सिबिलिटी दैट लीवे तो आई हैव एन ऑप्शन दैट इन माय ट्रस्ट डीड राइट आई कैन इन्वेस्ट इन these things also and if there is something remainder I can go to the Indian Trust Act also. That is what I wanted to say.
Okay, ma'am. Thank you. One more question.
Yeah,
Like
yeah.
you said, if there is a testamentary trust, then there is no requirement of registration because it is under a will. So once a person demise, then there is a picture of coming a trust into place. So whether at that point of time there is a requirement of paying stamp duty.
So testamentary trust is again under a will and there is no stamp duty.
Okay. And ma'am, with a settler, like you said, if a settler and beneficiary are same, then it may be regarded as a revocable
Revocable
trust.
trust.
Yeah. So there will not be any benefit of taxation.
So what happens is, see, today I'll just explain you. I know it's not in this today's thing, but suppose if you settle a trust, सपोज आपने 100 शेयर डाले रिलायंस के आपकी ट्रस्ट में, रिलायंस ने कल आपको 200 रुपया डिविडेंड दिया, वो ट्रस्ट के हाथ में टैक्स होगा, नॉट इन योर हैंड।
Yes.
आर यू विथ मी?
Yes, ma'am.
ट्रस्ट उसको टैक्स देगा, मतलब सपोज 30% टैक्स है क्योंकि वो अभी पूरा इनकम है, उसके बाद ट्रस्ट डिस्ट्रीब्यूट कर देगा वो इंडिविजुअल्स को टैक्स फ्री करके, मतलब खुद टैक्स भरेगा, इंडिविजुअल के हाथ में टैक्स नहीं रहेगा, बेनिफिशियरी के हाथ में। बट सपोज आपके ट्रस्ट में आप सेटलर हैं और आप ही बेनिफिशियरी हैं, करेक्ट?
Yes.
तो वो जो इनकम है वो टैक्स आपके हाथ में होगी पूरी,
Okay.
क्योंकि आप बेनिफिशियरी भी हैं, ये डिफरेंस हो जाएगा।
And when I will transfer the asset, immovable asset, then also there will be a capital gain implication on my hands. Settler के हाथ में.
सेटलर के हाथ में जब आप ट्रांसफर कर रहे हो, जैसे मैं सेटलर हूं, मैंने एक ट्रस्ट में इमूव प्रॉपर्टी डाल दी, तो वो टाइम पे टैक्स नहीं होगा, बट वो जो इमूवेबल प्रॉपर्टी जो है उससे अगर कोई इनकम होगी वो आपके हाथ में टैक्स होगी। सपोज आपने जो ट्रस्ट में डाली प्रॉपर्टी वो आपने कल बेच दी, तो जो वो कैपिटल गेन होगा वो आपके हाथ में टैक्स होगा।
Okay. Thank you.
Ma'am, there is one question. If a immovable property which is transferred in the name of trust, because trust is not a legal entity, can a immovable property be registered in the name of trust,
यस,
even without being a legal entity? This was a question.
यस,
Okay. Ma'am, I myself had one question. So, assume, ma'am, if I transfer a property to a trust for whatsoever purpose, and tomorrow, if there are some GST or income tax demand that comes on me, whether fraudulent or otherwise, or if there is any loan which has become NPA, can now the recovery proceedings against the loan, or whether for any taxation, whether fraud or not fraud, can it be initiated against the trust also because I have transferred the property in the name of trust?
So there are two things. One is that after I transfer it happens, then certainly not. They cannot attach because the property is not yours. But if I know that there is a proceeding going on and then in that interim I'm transferring, then they can do that. You will not get a certificate only and then you cannot do a transfer, I guess.
Understood. If there is any other questions which is there, we can take up.
Ma'am, one more thing. I have read in your PPT that you mentioned about no lien certificate letter, which we can obtain. So, from which authority we need to obtain that no liens letter or certificate?
No lien certificate.
Yeah, letter. I have read somewhere in your PPT.
That is for your registration. When you go for a registration, आप जब आपके इंस्ट्रूमेंट को रजिस्टर करने जाओगे ना, तो वहां पे एक सर्टिफिकेट इशू करते हैं वो लोग कि दिस प्रॉपर्टी इज नॉट अंडर एनी लियन, वो वही लोकल रजिस्ट्रार्स इशू करते हैं, वो पर्सपेक्टिव से है।
Okay, ma'am. Thank you.
So suppose if you have a lien, then you cannot transfer the property, right? Your
Yes,
property
yes.
title has to be clear. So for that.
Okay.
So I guess all the questions and queries has been amazingly answered. A person who does not have any knowledge of the trust today also can say that no, we know a lot about trust. That's how easily your presentation was today, in such a way that it starts from the scratch and gives you a very holistic view. Thank you for that, ma'am. Thank you for your time and thank you for helping us to understand trust with such great clarity. Because it has always been a gray area. We have always known, we have always heard a lot. We have seen a lot people making trust in movies and in real life as well. But today it becomes more clear ki what's the actual purpose and how, with a very big clarity, it becomes it was in your PPT and your presentation was. So thank you so much for your time. On behalf of ACI, I would like to thank you and thank all the participants. And I would like to remind all the participants कि बोलते ना आज तो ट्रेलर था असली मूवी परसों है. So if any one of you who has not yet registered, do register for the upcoming full day session on succession planning, which will again go into do a deep dive down into trust and legacy and succession and everything. So with this, I guess we can call off today's seminar. Thank you so much, ma'am, again, and thanks to all the participants for making this an amazing session today.
Thank you very much. Thank you very much for giving me this opportunity. And thank you for such a patient hearing. I hope I was able to do justice today to
Def-
everybody.
Definitely, ma'am.
And I've given
मैम
a
एक
predecessor.
एक बात बोलना चाहूंगा. Generally we see कि number of participants keeps on decreasing by the time the session goes on. मैम आज मैम the number of people who joined are at present till the end, even though we are few, but it was amazing to hear you and increase भी हुए, एक जन भी delete नहीं हुए, which is something really amazing to see, ma'am. Thank you so much, ma'am.
Thank you so much. Thank you. I just want to just say one more point here. So there are some nuances or some local laws which are different in stamp duty and registration laws. I could not clear earlier, which may differ state-wise. Matlab stamp duty and registration state-wise would be different. So one may have to check in which state the property is located. And secondly, one clarification which I forgot to give is that there are Indian Trust Act provisions that do not apply to Mohammedan laws and Wakaf. I forgot to give the disclaimer earlier. Just to keep that in mind, you need to just ensure that once before advising or making. That's it. And thank you everyone for a patient hearing.
Thank you, ma'am.
Thank you.
Thank you so much.